I'm going to do 8 for my argument, and then I'm going to reserve.
All right, we'll give you 10 minutes, but set the clock for 8 minutes on your argument.
Okay.
Thank you.
Thank you, Your Honors. This case is a little bit very complex in my opinion. I represent the father, J.H., in this matter. And this is a termination case that came out of Wilson County. This is a case where a man's rights to his child was terminated even though he did everything he was supposed to. And that is very unorthodox. My client, J.H., was on drugs at one point, but he got himself clean, got out of jail when he had to do a year, got a job, saw his child, did everything that he was supposed to, and his rights was still terminated. The problem with this case is this. DCS took my client's rights from his child, even though the time period that they looked at, they didn't consider him to be the father. So what happened in this particular case is my client, when the child was taken from the mother designated my client to be the caregiver for the child. Unfortunately, my client tested positive for THC and cocaine. At the time that this happened, my client was not on the birth certificate, and DCS did not consider my client to be the father. So when my client tested positive for THC and cocaine, DCS took the child and then placed the child in DCS custody because the mother did not designate anyone else for the child to go to. My client could not designate who could get the child because DCS did not recognize him as the father. My client then goes to jail in June of 2020, still not the father. A DNA test is done. It comes back in June of DNA test is done, and then in October of 2020, a DNA order is done establishing my client as the father. Now, in between that time, DCS does a permanency plan, and they have all these requirements for my client. But they also acknowledge that my client is not the father, and so in the permanency plan, they say that my client does not have to do certain things in the permanency plan until a DNA test is done. The DNA test is done, my client does nothing wrong at the time that the DNA test is done. But the permanency plans has certain conditions in there. For instance, you can't incur any more charges. You can't go to jail. But that was only after his DNA was established as being the father of the child.
What's wrong with that?
There's nothing wrong with that. The problem is that they used that time period where they were not requiring him to do these things to justify the termination. So what I'm saying is this, because he wasn't determined to be the father, there were certain things he couldn't do,
Right.
which is pick where the child went. But they used that same time period to terminate him. And I don't think that's fair.
Well, Swade, you're saying that your client did everything he was supposed to do here.
Right.
But wasn't one of the things a father is supposed to do is go establish paternity as soon as they can? I mean,
And that happened. That happened. The permanency plan, the first one was done in March of 20.
I mean, by filing, but not just a DNA test, but by filing petition for parentage.
The permanency plan said for the DNA test to be done, it wasn't a requirement for him to do it. DCS actually filed the petition for paternity while he was incarcerated. The DNA test was done, The order was done in October of 2020 while he was in jail. He wouldn't have been able to do a DNA test while he was in jail. DCS did it, he complied, he did the test, and it came back that he was
Well,
the father.
but what about up to the period prior to his incarceration? He was caring for the child for a time, but at no point did he go to a court at that stage and say, I'm the father.
That is true, that he did not go and say that he was the father of the child because he wasn't sure if he was the father of the child. But we're talking about a termination case here. In their petition to terminate, they never said that one of the grounds for termination is the fact that he didn't go get a DNA test. What they're saying is that my client is a drug user, and he rectified that.
Okay,
He
well-
had 11 drug tests, and he only tested positive twice,
But-
and that was in March of June of 2020.
But the
After that,
the
he was-
trial judge gave him credit for that and said that he had been clean. But what about the other persistent conditions about not having housing and maintaining other consistent things?
My client did have housing. If you look at the record,
Well, he was sleeping or staying at other girlfriends' houses from time to time.
if you look at the record, I'm not sure if the record reflects that he was staying at other girlfriends' houses at time to time. If you look at Shonda White, he was living with Shonda White, then he lived in Shelbyville, and then he had this house on Hanover Street where he had been staying for 18 months. The court order says that my client has suitable housing and had stable housing. There's nothing in the record that says that he was staying with this girlfriend and that girlfriend and that girlfriend. What the state was trying to establish is that SW, he wasn't staying steady with SW, but that is not what the record reflects if you look at the supplemental brief when SW testified. The state did not establish that my client was living from pillar to post. The record is, there's nothing in the record that establishes that he was not stable. In the record, you will see that DCS testified that he had stable housing, and the court also said it in the order that he had stable housing.
So what I think I hear you saying is that after he found out he was the father, he did everything he was supposed to do, and he went straight and didn't do a significant amount of drugs and got off drugs and had stable housing and everything, and we shouldn't worry about what things were like before he was found to be the father. Is that right?
Yeah, well, yes, but if you look at the things that he did before he was found that he was the father, he was taking care of the child, he was with SW, he was providing the child with the care that the child needed, but you have to be fair. If you're saying that this man can't pick where this child goes because he's not the father, then why are you using that same time period to terminate his rights? And that's just not fair. I think that JH should be treated as a father if he's a father and treated not as a father if he's not. If he had the ability to pick where the child was going during this period where they say that he should be terminated, then that would be free game. But you can't say in one breath, we're not gonna treat you like a father, but whatever you did when you weren't the father, we're gonna use against you for the termination. I don't think that is fair. I think that parents should have the right to get themselves together, and that's what Mr. Humphreys did. And the only thing that we're dealing with right now is what did Mr. Humphreys, what did JH do after he was determined to be the father? And there is nothing to say that he violated anything in the permanency plan, persistent conditions, or anything like that.
All right, thank you, Ms. Wade. Good morning.
Good morning, Your Honors. Attorney Jerry Beeson, Davidson County. I represent the paternal aunt and uncle in this action, and I will not need my full 5 minutes. With permission, I'll give it back to Ms. Wade. The paternal aunt and uncle in this action had filed a motion to intervene and a petition. They were represented by another attorney. I was not the attorney at the trial court level. The motion to intervene, the petition attached as an exhibit, was set to be heard a couple different times per the record, and it was never heard. They pro se filed a notice of appeal once they got the order, and it was a form order from juvenile court, from judge, the trial court judge. And in that order, it just said that their motion was dismissed. It gave no findings of fact or conclusions of law. And frankly, Your Honors, if I don't have that, I don't have anything to argue. And looking at Rule 52.01 and looking at the fact that that wasn't on there, there's nothing for me to argue but to say, I understand this is sort of dovetailed with Ms. Wade's case and this TPR, but they don't have findings, fact, conclusions law, which we're supposed to do. And during that process, the courts speak through its orders, and during that process, and I gave the history of the case in my brief, and frankly, judges, this was extremely confusing. This record was very big, and they had different docket numbers in all these different orders and things like that. It became very confusing, but it was obvious that my clients had been a part of this action since the child was removed prior to the TBR being filed, all the way through. They'd had visitation with their nephew for a long time, extended visitation. This happened for forever. And every time they filed a motion for something during this proceeding, and even the prior proceedings, it wouldn't be heard, or there'd be a sua sponte motion without notice by the state to dismiss it. And then it would just be dismissal orders. There was never anything heard. So the only reason I'm here today is when they approached me, asked me to help them, I said that I would, because I looked at that order and there's just no findings of fact or conclusions of law, because their motion was never heard. Although they had an attorney that sat there every day waiting to be heard, it wasn't heard. And I've read the state's brief, understand the state's position. However, I can't argue law or case law if I don't have findings of fact or conclusions of law, and we just don't have that. So that's why I'd ask for the trial court to be required to get findings of fact and conclusions of law to see where they are, and to give your honorable judges a reason as to why it was dismissed. And that's the time that I would use, and I would.
If you would help me with the time frame, and this goes back to when Ms. Wade's client was declared the father of the child.
Yes, sir. From the best of my recollection.
At what point was your client's petitions filed in relation to that?
They had filed, there was motions filed during the Penn neglect timeframe. And they started doing the ICPC process back in June, I think, of 2020.
And that was before he was declared the father?
Yes, sir.
Okay.
So it was before he's declared the father. I think that original DNA test was ordered in June. I don't think that he was declared the father. I don't think those results come back maybe at the end of June. But one of the interesting things that and I could be wrong about this, Your Honors, but there was a paternity order declaring him the father, I believe in the record, that I don't think was signed by the judge. I think it was October of 2020. And during that time, my clients had participated in all these CFTM meetings, participated in visiting with the child, and they were part of the child's life because that was the paternal aunt's nephew, paternal uncle's nephew. And then it was almost as if it was fast-tracked. They get this order, and I could be wrong, judges, but I don't think it was signed by the trial court judge's paternity order. I don't think it was signed. And all of a sudden, they're waiting on this ICPC stuff. They'd given all their information back in June of 2020. The DCS worker was pregnant, I believe, and took off work and was out of town. They sent stuff to Alabama, but did not have a paternity order, so it delayed things for their ICPC.
So it's fair to say that your client's position would have been improved had father petitioned for paternity much, much earlier in this case.
Well, I believe that he could, I will say this, Judge, if paternity had been determined early and an order would have been signed early, I believe the ICPC would have been granted early, and then they would have had, and I think the trial court judge had the intention of using my clients.
Sounds like the answer to my question is yes.
It is, but I think that he was incarcerated at that time, and DCS ordered for that to happen, and it did happen, but that order didn't go in until like October of 2020, and throughout this record, it was really confusing because you had my clients their attorneys filing motions on their behalf that were just getting set aside or saying, no, we can't do anything because the ICPC's not done, we can't help you, and all of a sudden you get a TPR. They filed motions regarding that, and they filed a motion to intervene in December 8th, I believe, of 2022 maybe, and it was never heard. Judge said, yeah, we're going to hear this. The trial went on for the TPR. He never heard it, and he didn't get findings of fact or conclusions of the law, so it's been extremely frustrating.
But when did your clients file the petition to intervene in relation to when was father declared the father?
I'm trying to remember, Judge. I believe they filed, I apologize, I believe October 20th was the order that I saw, October 2020 is the order I saw, and I think they started filing motions then to have the children. But they filed December, I believe I apologize, Your Honors, I'm getting the date confused, but it was December 8th, I believe, that they filed a petition to intervene in the TPR, and I think that TPR had been filed maybe 6 or 7 months before, and I apologize, I'd have to look at my timeline. And
Your client's petition to intervene was filed after father was declared the father?
I believe so, Judge, yes.
But
And in the meantime, the motion
but their
was filed.
petition to intervene was filed after the petition to terminate the father's parental rights was filed.
It was, Judge.
Okay.
And prior to that, other motions were filed trying to get involved, but
Yeah.
he had not been determined
Right.
as the father, so they couldn't let them help.
Okay, all
Yes,
right.
sir.
Thank you,
Thank
thank
you.
you, sir. All right. Good morning, sir.
Good morning, Your Honor. May it please the court, my name is Wade Barnett with the Tennessee Attorney General's Office, and I represent the Department of Children's Services. The first issue I'll tackle would be the motion to intervene. So there were multiple motions to intervene filed throughout this case. The first one was filed after the paternity had been established. The first one had been filed in March of 2021, and the termination petition had been filed in February of 2021. And so that's not the one that's at issue before this court today, because that one was denied and it was sent on appeal to the circuit court as part of the dependency neglect proceeding. And that dependency neglect proceeding has been stayed pending the outcome of the TPR. So the only petition that's before this court today was the one that was filed in December of 2023.
December of 23.
Yes. And that is when we were in the middle of the termination petition. The trial was ongoing at that point. And regarding the lack of a hearing, one, that's harmless. Trial courts have absolute discretion to hold hearings on motions, absent a local rule to the contrary, and a local rule was not cited here. Regarding the findings of fact and conclusions of law for the 2023 motion to intervene, the order is scarce. It does not have any findings of fact. All it says is motion is denied. However, the department would contend that that error is harmless, and we would ask this court to soldier on with its review for two reasons. One, this case has been pending for 5 years now, and the child has been in foster care for 6. The legislature has espoused the view that termination proceedings need to be determined quickly and expedited, and further litigation would not benefit the child in any way, especially because, for reason number 2, the motion lacks merit. This is a termination of parental rights case. The aunt and uncle do not have by right a right to intervene in a termination proceeding. They're not seeking guardianship of the child, and that's the purpose of a termination proceeding, is to determine, 1, is there a ground for termination, and 2, whether the termination's in the child's best interest. And so they don't have a right to intervene, so they only have permissive intervention. But again, they're not seeking guardianship. They're seeking custody. They're seeking placement, which is not the purpose of a termination proceedings. So ultimately, their issue is irrelevant to a termination proceeding, and the trial court did not abuse its discretion in ultimately denying the aunt and uncle's motion to intervene.
So you're saying at no time did the aunt and uncle file a petition with the court to intervene for the purpose of adopting the child?
Correct. Aunt was very clear. She was asked that question during trial, and she said that she only wants placement of the child, and the ultimate intention is for the child to return to father's custody from her perspective.
Okay.
So with that, I will move on to the grounds for termination. The first ground the trial court found was the abandonment by wanton disregard ground. Opposing counsel has argued that father's paternity was not established during the applicable time frame. However, for the wanton disregard ground, that's not the relevant inquiry. The relevant inquiry is whether the father had knowledge of the child's existence at the time he conducted his acts. And father knew that the child existed at the time he...
But did the father know that it was his child?
He said he had suspicion. A mother told him that, that she was pregnant.
But she never told him he was the father.
No, but he had a suspicion, and that was his testimony.
Is that enough to put a burden on him?
Yes. Again, paternity is not the relevant inquiry. It's about whether he has sufficient knowledge of the child's existence at the time prior to his incarceration. And even then, even when he...
The existence requirement comes from times when cases where the father knew the child was in utero. It hadn't been born yet.
Correct.
I mean, can we really extrapolate that to just knowing this child is out there without knowing you're the parent?
Well, and there's two aspects of it. One, the father knew, again, that the child could have been his, and that mother told him that she was pregnant when she was 3 months pregnant. But then there was a, excuse me, but there was a period of time after the child's birth where the father took on sole care for the child. I say sole care, but I mean, he alternated care between himself and mother and Miss White prior to the child's removal. So he held out the child as his own, despite not knowing that the child was completely his. And at trial, the father testified that he didn't do a paternity test because he was afraid that the child was not his. And in this case, the timeline...
Now, did the crime occur while father had custody of the child?
So there are multiple sorts of conduct here. The first source of conduct was in January of 2018, a couple of months before the child's birth, while the child was in utero.
So that cannot, well, go ahead.
So, and he was indicted for that charge for those charges in 2019 when the child was in his care. And then in March of 2020...
He was indicted while the child was in his care.
Correct.
But the alleged conduct was before.
Yes, 2 months before the child's birth.
Thank you.
Yes.
Please continue.
Okay. And then the next set of conduct was at the time of the child's removal. The father tested positive for cocaine and THC. And then in May of 2020, father assaulted mother. And he was indicted for aggravated assault by strangulation. And he eventually pled guilty to a lesser included offense. But that was while the child was in the department's custody at that time. And that was before his incarceration a month later in June of 2020. So the full conduct in this case demonstrates a abandonment by wanton disregard for the child's welfare, because even before the child's birth and after the child's removal, father continued to engage in criminal conduct and in drug use. Let's see. I see that my time is halfway through, so unless the court has any questions about the permanency plan or the failure to manifest grounds, I would like to use my remaining time to address the best interest of the child.
Well, I'm still interested in the other grounds.
Okay.
Because I see findings that the trial court said the father has done wonderful things. He's been compliant with the drug criteria. He's not tested positive on any drug test, etc.
Yes.
And I'm a little troubled as to the other grounds.
Yes, and so for the wanton disregard in particular? So.
You pick. But,
Okay. Yes. For the wanton disregard ground, we look at the period pre-incarceration, 4 months prior to the filing of the petition, and that's the specific timeline that we look through for that particular ground. For the other grounds, yes, father has, after his incarceration, he has tested negative on all his drug screens, and he has accomplished certain responsibilities. However, he still has not accomplished all of his responsibilities for the permanency plans, and ultimately he has failed to manifest an ability and willingness to assume custody of the child. In particular, one of the main issues at trial was his housing situation. Prior to his incarceration, father was transient. He lived with multiple people. He lived with his sometimes girlfriend. He lived with his mother's relatives. And even after his incarceration, father lived at a halfway house, but he was kicked out. He acquired an apartment. He then acquired new charges in 2022, which were ultimately dismissed, but he lost his housing as a result of that. And then at the time of trial, he resided in an apartment by himself, but his lease was not on his name was not on the lease of the apartment. Instead, it was his fiancee's name on the lease. And she did not reside there. She lived in a separate apartment. And so ultimately, and it's uncertain, and the trial court found that the relationship between father and his fiancee was uncertain because she was not involved with his trial at all. She didn't testify, and father purposefully left her out of the trial court proceedings. And kind of going into the failure to manifest grounds for ability and risk of substantial harm, that is an issue because, one, the child is a complete stranger to father's fiance. He's not met her, he's not talked to her. Father testified at trial that he planned to use the fiance as a kind of help to help raise the child, but father never discussed his plans with his fiance about how to raise the child. And when asked if his fiance would not help, he said that a random third person would help him out. But we don't have any long-term care. Father did not have any established long-term care plans for this child. He didn't go into the child's schooling, and he said he was going to wait till the outcome of these proceedings before he made any plans. And ultimately, to go into the other issues, father had weekly visits for about 2.5 years. However, at the time of trial, father didn't know the child's likes. The trial court asked him, what's the child's favorite color? What's the child's favorite cartoon character? And father did not know the answer to that question. His testimony was that he hadn't had enough time with the child, despite having 2.5 years of weekly supervised visits with the child at that point.
It's an interesting problem in my mind, because the trial court credited him for going to almost every visitation that he was afforded, but then the trial court said, well, he wasn't really that involved during the visitation, and
Yes.
I'm having a difficulty with that.
Yes, and father did attend all the visits, and any visits that were missed were made up. However, it wasn't the quantity of visits that's the issue; it's the quality of those visits. Over the course of 2.5 years, the relationship between father and the child did not improve. It was described at trial that the quality of those visits were hit or miss. The child never asked for additional time with father. The child would often go off play by himself or with other children rather than stay with father. And the trial court held in its order that father mostly attended visits for his own sake rather than the child's sake. And he kind of spoke as matter-of-factly about the child at trial. So ultimately, that affects the child's best interest because the child, even despite having 2.5 years, does not have a significant relationship with the father. At trial, father had an expert testify, and that expert testified that the child referred to father as the visit guy. Like, that is the child's relationship with father. Even though the child would say, yes, he's my dad, he's still the visit guy to me. In contrast, the child has formed a deep bond with his foster family, whom he's lived with for almost 6 years at this point. He views the foster family as his family. When asked to draw who his family is, the child drew the foster family. He's most thankful for his foster brother. He wants to do everything with his foster brother. And he's asked the foster brother to attend visits with him with father. So At this point, I see that my time is running out. The department would ask this court to affirm the termination of father's parental rights. The child has a well-established home with his foster family. His bond with them is very significant. In contrast, the father has not bonded with the child. And although father has had significant improvements over the course of 5 years, it is not within the child's best interest to return him to father's custody. And if there's any other questions, I'd be happy to answer those, but otherwise, I would conclude my argument there.
Hearing none, thank you, sir.
Thank you.
All right, Ms. Wade?
Based on the questions, it appears that we might be stuck on this wanton disregard part with the termination. Now, Mr. J.H. did not know that this child was his. These charges that he incurred were in January of 2018. BK was still pregnant. This child wasn't even born. I know that the state said that when my client had gotten indicted that he had the child in his care. There's nothing in the record that I recall that says that. There was a charge that he pled guilty to while he was incarcerated in December of 2020 for something that happened in May of 2020. This is before he was determined to be the father, and there's no proof that that occurred in the presence of this child. Just because someone is convicted of a crime does not automatically mean that they lose rights to their child. You have to show how it's related to the safety of the child. I want this court to look at the state's brief. The brief and the order don't match. This court has to look at the order that the judge did. The order that the judge did does not meet the clear and convincing standard. The brief is trying to fix the order, but that is not how it works. I'm here on appeal to the order. And the order fails to meet the clear and convincing standard. It fails. None of the requirements for termination are there. You can't in one breath say that that JH has a stable house, and then in one breath say he doesn't comply with the permanency plans, when all the permanency plans said, all the orders said that he was in compliance. He became non-compliant, I don't understand why, even though all the orders said that he was. So I'm asking that you look at the order and not the brief when you determine if the standard was met.
All right. Thank all three of you for your arguments. We'll take this matter under advisement. That concludes the morning docket.